Okay, welcome back everyone to our post-afternoon break session. For those of you that are curious, these are our socials. If you are so interested, you may check us out there, and if you'd like to follow us, all the better. And for anybody who's interested in leaving us a review about the conference or some of the work that we do have QR codes all around the front, on the tables down here, and up here as well. Please feel free to scan the QR code and leave us a review if you so like. And I'm going to give people a second to scan that if they like. Okay. All right, and for those of you that missed it, okay. I'm waiting. All right. They're on the table. They're on the back of your agendas too. Yeah. All right. That's all right. It's been a long day. So now I'm going to introduce our next speaker. So our next speaker is Dr. Mandi Gray. Dr. Mandi Gray is an assistant professor at Trent University, specializing in gender-based violence, sexuality, and the law. With over 15 years of experience working with women and girls in the legal system, Mandi is also the author of Suing for Silence, Sexual Violence and Defamation Law, which is a book I have on my desk quite frequently, unfortunately. Today, Mandi will present on supporting survivors in litigation. Please join me in welcoming Dr. Mandi Gray.
Clicker. Hi, everyone. It's so nice to be here, and thank you for the invitation to... Actually, this is a brand new presentation on new-ish research that I've been doing since my book came out. So I'm really excited to present brand new research findings to all of you and maybe get some feedback. So as mentioned, professionally, I'm a faculty member at Trent University in Peterborough in the criminology program. And I primarily research in the area of gender-based violence, but I also do quite a bit of research in Indigenous community health to kind of balance out my research. And so I guess, that's me. So I'm going to be talking quite a bit about my research, but my research has really been rooted in my own experiences. Beginning in 2008, when I first started working with women and girls involved in the legal system, I worked and volunteered at Elizabeth Fry Society of Manitoba for about 6 years. And that's where I really became passionate about the unique experiences that women and girls who are incarcerated experience. And in Manitoba, a majority of whom are First Nations, and estimates of 90 to 100%, I would say, would identify as having experienced either childhood sexual abuse or sexual assault as an adult. Although most of the women I worked with were charged with criminal offenses at the time in 2008. We also had many clients of ours were in the residential school settlement process, and so I saw a lot of those women coming into incarceration and shared a lot of those experiences of going through the settlement process, which was quite challenging for a lot of different reasons. I moved to Toronto in 2013, and I started grad school, and much of my research then was about women involved in the criminal legal system and provincial jail. And in 2015, I also have personal experience of having reported a sexual assault to Toronto police. I went through a pretty high-profile criminal sexual assault trial at the time, which, as Kelly mentioned, I made a film about it if anyone's interested. It is on Amazon Prime. It is originally titled Slut or Not: The Diary of a Rape Trial. However, Amazon censored us, and now it's called just The Diary of a Rape Trial. And Simona is actually also in the film. So it is available to stream if folks are interested in hearing more about my own personal journey through the criminal legal system. And then through that, in 2015, I entered into the criminal legal system. I have also launched a human rights complaint against my university for the lack of sexual assault policy that existed there was no sexual assault policy at the time, and now we have provincial legislation, so things have shifted for the better, depending on who you ask. And I've also had the experience of being sued in defamation in 2018 for my advocacy work. I've been involved in the legal system for 11 years, come February 1 of 2026, with no end in sight for me. So a lot of what my own lived experience has really informs my research, but I think it also allows me a unique entry point to connect with people who have also navigated the legal system. I'm going to focus more so on my research as opposed to my own experiences in the presentation, but I am forthcoming about my own experiences because I can't erase those, and they do absolutely shape both my analysis and how I approach the topic. So, as mentioned, I wrote a book. It came out in 2024 with UBC Press. It's called Suing for Silence. I do have a discount code if anyone's interested. That'll be on a slide at the end. And from that book, I was interested in talking to survivors. And it wasn't even just survivors, which was a surprising finding from that research. It was also people who had supported survivors, who took actions to hold somebody accountable for sexual assault, for example, faculty members who supported a survivor navigating the reporting process. And all of the participants in that research had been sued or threatened with a lawsuit for reporting or disclosing sexual violence. And so the output from that work was my book, Suing for Silence. And I did a big tour with that book, and after talking to a lot of lawyers and survivors, I realized there was also not enough research in the area of civil litigation for survivors more generally. There was a lack of support networks for those who were thinking about going through a civil suit. And so I broadened the scope of this next research project, which will eventually be a book, to look more broadly. So both the entry point from those who are sued in defamation, as well as those who initiate a civil suit, which unfortunately seeing more and more frequently result in a countersuit in defamation. So this is all new research I've never presented on before, and it's combined of 39 interviews with survivors, or we could say silence breakers more generally. As I mentioned, several were not actually the ones who identified as having experienced sexual violence, but were acting in a support role, and many of which were professors or advocates. And then I've done interviews with 28 lawyers or advocates from across the country. All of the interviews were transcribed and thematically coded, and don't worry if you don't know what that means, it's just academic jargon. I've also done a very extensive analysis of media articles, archival materials, legislative documents, and of course case law. And I've spent a lot of days in court watching primarily defamation proceedings against survivors, but more recently watching a civil sexual assault trial as another entry point to better understand what happens in courtroom, and comparisons to what happens in criminal civil sex assault trials, which are there's a bit more research on that in a comparison to what happens in the civil legal process. So these are all taken together to inform sort of this new body of research that I'm working on. And I'm going to talk briefly about some of the motivations that I heard from the interviews with survivors. And really, a lot of the motivations for why they wanted to initiate civil action was very similar to what we hear for other types of either reporting to police or reporting within the workplace. And the primary thing that I heard in my interviews was this really innate desire to protect others from harm, whether it be from the individual perpetrator or the conditions that allowed for the abuse to happen. Accountability is a word that comes up very frequently, whether that's the institution taking accountability or the individual perpetrator. Oftentimes that was looking for recognition or an apology from the institution or the individual. Justice, which I guess is intersected with accountability, really about having that public recognition that sexual assault did occur, and that the courts would hold that person or that institutional accountable for what had occurred, and there would be a court record or decision that would validate the harm that was done to them. Public knowledge was also a recurring theme of wanting people to know, whether that be through the court process itself or whether it be through news media or even just within the small social circles of different, I'm thinking of workplaces, for example, to better inform others and again to change systems, conversations, or cultural norms around sexual violence. Systemic change was also a big motivator for many of the people who had initiated civil legal action. And systemic changes could look like a wide array of different things in terms of what they were hoping for. So for example, I talked to a couple of women who were working in the oil fields, which is a primarily male-dominated field, and they were really hoping to bring more gender equity policies and recognition of harms that are unique to the women in the workplace, specific to Northern Alberta and BC where they were working. Other systemic changes could be just the different institutional policies that allowed for the perpetrator to harm them. And I know this won't be surprising to anyone in this room, but I think it is surprising to the more general population was how infrequently survivors noted money as a motivator for them. It's not to say that nobody thought the money was important, because they did recognize that having a settlement or a damage award would be very beneficial, for example, for paying for things like medications. One woman had an unwanted pregnancy and was now having a baby. These were all things that had a dollar sign attached to them, right? And so it wasn't that the money wasn't important, but there was very much a justification. And also, too, the money could also be used for things like systemic changes. So one woman I interviewed, for example, had a kind of creative settlement agreement, and that part of it was the institution had to give her money to create a foundation to provide support for women who were sexually harassed in the workplace. So there was oftentimes justification, and I think that was a surprising finding to the general population, but not so much probably to this room. But it was very, very not common at all to even bring up the monetary elements of why they were suing. And I forgot to mention that none of the civil sex assault claims of the folks that I interview had made it to trial. All of them had ended at settlement, but a lot of them were also, as I'm sure many of you know, the civil legal system can take many, many years to resolve. So I also spoke to a lot of people who were kind of in the middle, either at discovery or had just filed their civil claim. So I hadn't talked to anyone who had actually gone through a civil trial. And the other limitation of this that I forgot to mention earlier is that I haven't been successful in recruiting male survivors yet. And so the research findings are really not generalizable to everybody, but really just the women and gender non-conforming folks that I have interviewed thus far. But I have a bit of a slide on recruitment if anyone knows anyone who might be interested in chatting with me at the end of the presentation. So I think this is where it often comes to a really challenging point for many of the survivors that I spoke to in terms of what a civil lawsuit can do, what the intention of tort law is, and their expectations of what's going to happen versus what actually happens. And here's really critical to that we all are in agreement that the intention of tort law is to provide monetary compensation, which is very at odds with the motivations that I heard from survivors. And so this misalignment can sometimes result in really extreme disappointment when compared to the initial motivations or the expectations that they had. And so it is really critical that survivors are aware that some of their expectations may not be met, but that maybe civil litigation can be used as one tool with an array of other options available to them, for example, using media or their own advocacy work. And it's not to suggest here that survivors shouldn't initiate civil legal action, but rather more needs to be done to set really clear expectations about what the civil legal system can do. I spoke to many survivors who had fantastic lawyers who did a really good job of setting this expectation. And unfortunately, I spoke to a lot of survivors who didn't have great legal counsel, who created very unrealistic expectations for their clients. And like I said, it doesn't mean that the other motivations can't be met through civil litigation, because I can think of several examples where civil litigation has resulted in those systemic changes that many of the survivors are looking for. I think of Jane Doe versus Toronto Police as a clear example that really changed the landscape, both for sexual violence, but also ability to sue police. And the ongoing class action lawsuit against WestJet, or, for example, the Truth and Reconciliation Commission was actually the result of a legal settlement. So there are these avenues, probably more so in settlement than at the court, in which these outcomes can influence change, systemic change, and many of those other things that survivors are looking for. But I think it's also so critical to acknowledge that litigation is so adversarial in nature, and it's going to be really challenging. And so really the intention of my process here is to better inform folks on how to support as clients, future potential clients, go through that civil litigation process. I know from my own experience, I've had fantastic lawyers throughout my journey, but it's really isolating because also a lot of people don't have that experience, therapists, counselors, folks at sex assault centers, and so they're kind of at a loss as to how to support somebody going through either the criminal legal process or the civil litigation process. And so here, while there are some things that can be achieved through civil litigation, I think it's also really important to set the expectations specifically around that apology and the remorse and what's a more realistic outcome. And I have a couple quotes, not too many, from lawyers, but I thought the next two quotes really spoke to the key elements of what lawyers were seeing in their practice. And so I'll read this to you. Some people are looking for genuine remorse and they don't want money. They want an apology. You know, you can negotiate an apology as part of a settlement, but in my experience, the apology is pretty hollow. It's never going to give you what you want from that person, which is actual genuine remorse. I mean that maybe that could happen, but I haven't seen it yet. And that was from one of the lawyers I interviewed. And another lawyer says, because a lot of people will say, I want an apology, and the court can't force an apology. What is an apology if it's not meant? If they're just saying it to make you happy. Is that what you want? Because to me, it's completely meaningless. All we can get is money. We can't get apologies or anything like that. I mean, sometimes people do, and they are quite genuine, but not very often. Of my 39 interviews, I did interview one woman who did get an apology, and it was really interesting talking to her because several years had passed since her settlement. And she did share that when she initially got her apology, she felt it was very hollow. She didn't feel like it was genuine, and she was genuinely upset by the apology that she got. However, years had passed since she got the apology and was more reflective and said, you know what, most people don't get this. I'm actually really, I'm glad I went through the civil process. I'm glad I got this apology and recognize that most people won't get that apology. But that wasn't something that I saw regularly or routinely, and that was neither something the lawyers I had interviewed saw quite frequently either. But not to say it didn't happen, but it just wasn't the common occurrence. And I think that's something, too, that maybe sometimes some lawyers and maybe others overpromise or overdeliver in terms of what is actually going to happen in that court or settlement process. I'm going to focus primarily on the challenges. And of course, there's so many challenges with litigation, but I picked out these three because these were kind of the most reoccurring thematic areas from the interviews that I heard. And of course, focusing on challenges because I'm going to be talking about supporting survivors, and folks usually need most support with challenges. I will maybe do another talk on the benefits of civil litigation at another conference sometime. And so I'm going to talk about retaining legal counsel. That was probably one of the most stressful and re-traumatizing. Well, I guess all of them are a little bit re-traumatizing, I think, to different degrees. But retaining legal counsel was a huge challenge. Finances, which is an obvious one, given the civil legal system. And it is about money at the end of the day. And then discovery and trial. And here's a couple quotes I had from two of the interview participants that I asked them about how did they find their lawyer, was usually one of the first questions I lead with. And she said, "I want to write a book about how a survivor can navigate the legal system and find a lawyer who can take on complex cases." And that was kind of a reoccurring theme because oftentimes the cases involved either multiple parties, complex processes within institutions or different institutions working within one another, and it was often too complex for sole practitioners to take on, and the larger law firms were not always keen to take them if they didn't have a conviction in the criminal courts. But finding a legal counsel was often one of the biggest barriers for survivors. Some of my participants identified their legal counsel through reading about news articles and then recognized their own story and reached out to the lawyer, who then they went on to have a good relationship and retained them. So folks that had a criminal conviction had the most success of not just retaining counsel, but staying with their counsel throughout the entirety of the civil process. Similarly, when there was an institution involved, so for example, school boards. However, others who didn't have a criminal conviction, if the charges were never laid, or if they were hoping to sue an individual perpetrator, oftentimes had a really difficult time finding a lawyer and felt that they had to retell their story many, many times, had a lot of unanswered emails before even getting retained. And several, unfortunately, of the participants I met with had gone through multiple lawyers because once the lawyers got more information, for example, the woman that is from the first quote, a lawyer she retained issued a civil claim, and then 2 weeks later she got a letter of disengagement and said the lawyer was no longer going to represent her. And so she felt very much abandoned by counsel. And of course, this is also one challenge, was really no way around it. If the lawyer is actually considering their case, they probably need to hear about it to make the decision about whether or not they want to proceed. And that felt very difficult to tell their story and then get the, no, I'm not going to proceed. I don't really know if there's any way around that. I think even the participants I spoke to recognized that they would likely need to share the details and documents if a lawyer was going to take their case. And a common thread in the interview was really, this was an interesting one. So this is from one of the interview participants, and she said, "I think that not having just a personal injury lawyer, but someone who specializes, who understands the victim, who understands what they're going through is so important." And she really highlighted how it was so nice to have a lawyer she didn't have to explain things to. She didn't have to explain how trauma worked or why the impact that the abuse had on her throughout her life course. With that being said, I talked to a number of survivors in more rural and remote communities, for example, in Yukon. There's not a ton of lawyers to pick from in Yukon. And they spoke very highly of those lawyers too, if they demonstrated empathy and all the things that we were talking about in the previous Kelly and Iona's presentation of like being listened to. And so I do think the specialization in trauma and sexual abuse is really critical. But I also heard from a lot of interview participants who maybe didn't have a lot of lawyers to pick from just by virtue of where they're located, who had really positive experiences with their lawyers, who maybe weren't experts in sexual assault, but really took on their cases because they saw merit in their case and really wanted to advocate for them. So I think that's an important caveat, that there is also the ability for lawyers to learn and make mistakes, and many of my participants had really strong relationships with their lawyers. One went so far as calling her lawyer her best friend, simply because she had nobody else that she could talk to about the case in her personal life. So I think the other thing, as folks are maybe supporting someone, is to really think about your lawyer, and that's like a really long-term relationship that you're entering into potentially, and can you work with this person on a long-term basis? And those are just one of the many considerations, and one thing I tell folks when they reach out to me and ask me, should I sue this person? You know, like, do your work, meet with different lawyers, and see, like, and envision if you can work with them long term. Of course, finances was a massive one, but it came up in different ways. So the financial realities of litigation was obviously a big consideration, and it wasn't so much about what the award might be or the settlement, but rather the direct and indirect costs of litigation. So I talked to several survivors who continued with civil litigation, knowing that they would never recoup the costs from their lawsuit. And they did it for many of those motivations I talked about at the beginning. This caused pretty significant financial strain for them. So one example is a woman remortgaged her home to pay her lawyer an hourly rate because she wanted that justification. And this put her in a pretty financially precarious position. And even those who didn't have to pay hourly because they were represented on contingency, meaning that the lawyers would take a certain percentage at settlement or whatever the damages award was, they still spoke quite a bit at length about both direct and indirect costs of engaging in the litigation. So this could be, and this was a common one, was missed opportunities due to trauma symptoms that emerged every time something happened in the case. So there's a motion and the outcome wasn't what I hoped it would be, and now I'm gonna take a few days off work because I feel sick. That was kind of a common one in terms of the major updates about litigation, or having to collect documents for discovery was quite time consuming for many of the survivors, especially ones that had a lot of documents that they needed to assist in locating. The cases, for example, where the sexual assault happened in the workplace often resulted in reputational harm to the survivor who reported, so missed opportunities like promotion. In my first book, I talk about a woman who was denied tenure after she reported, and then she had to appeal the decision, tenure at the university, sorry. And I've spoken to several people who have had pretty significant consequences on their professional reputation as a result of either being sued in defamation or engaging in the civil legal system. A major finding, again, too, and this is replicated in a lot of healthcare studies, was just really significant health outcomes, negative health outcomes, which is replicated in many studies linking trauma to healthcare. Autoimmune disease was frequently attributed directly to the trauma and stress. And some felt like, especially for the folks who got sued in defamation, because you have to consider when you're sued in defamation, you don't consent into the civil legal process. There's no one talking you through, okay, this is what's gonna happen at discovery. No, you're going in. You can't really just exit out. And so for many of them, especially the folks being sued in defamation, I talked to many who had autoimmune diseases emerge following the defamation suit against them. And then, of course, mental health therapy, medication. Those things aren't free for folks that don't have insurance or benefits, often paying out of pocket. So there are very, very tangible costs attached to being sexually assaulted, and there's tangible costs attached to engaging, whether it be the criminal legal system or the civil legal system or reporting just generally. I think I'm at time. Yeah, okay. So just briefly, discovery. There's a lot of different tactics that lawyers assisted with discovery and trial, prepping for disclosure of personal documents, conduct of opposing counsel, and the perpetrator were both very much indicators of how it would go, and there are lots of examples of good advocacy, both from opposing counsel, and there's a lot of not so great conduct of opposing counsel. I talked way too much, because I guess I'm very more excited about this new research than I realized, but I'm happy to chat. I just wanted to, I'll just focus on a couple things, what to consider when prepping someone about whether to make the decision. Of course, support system, who's there for you, family, friends, therapy, your overall health and well-being. Like I mentioned, many of the survivors I spoke to are dealing with a lot of other health consequences tied to their the abuse that they experienced, which takes up a lot of time and advocacy in and of itself to navigate the healthcare system, timelines, life priorities. I know I talked to one woman and she talked about how it impacted her dating life, saying she had now had a cargo ship of baggage and she wished she didn't know how to navigate these these life milestones. So I think those are things to take into consideration, the projected awards and the ability to actually collect. And finally, the personal cost of doing nothing or silence, and I think that's a big one. I'm biased because everyone I spoke to had been involved in the legal system, but for all of them, the personal cost of doing nothing, for not initiating some sort of report or legal action, felt like that would be the worst punishment of it all. So I think you really need to also weigh like the potential for healing through speaking up and using your voice, but it's not for everybody, and that's okay too. And I am recruiting. I'll leave this up and I'll stop talking so I don't delay anything. But if anyone's interested in interviewing with me for this book, I'm interested in talking to anyone who's had legal action taken against them or have initiated legal action for sexual violence. I'd be happy to talk to you for my next book. And thank you so much for listening to me.
Thank you, Mandi. I'm just going to take a second to talk a little bit about what Mandi just said. One of the reasons why we do this work is because we recognize that it is very specialized work and our clients are very, very special people. And one of the reasons why we put on conferences like this, or one of the reasons why we participate in cross-Canada conferences, is to teach other lawyers how to do this properly. When I first started this 28 years ago, there was literally 5 other people, other lawyers across the country that did any kind of this work. And now, for lots of different reasons, there are an awful lot of lawyers who are getting into this kind of work. And the ones who want to do it well learn. And we're here to teach them. We're here to show them our experience, help them with their cases so that they can actually do the best possible job for clients. One of the other things that I actually just wanted to mention as well is that Mandi talked about cases bringing on change, and she talked about criminal cases bringing on change. But I guarantee you that in seeing how institutions have dealt with their policies over the course of the last almost 3 decades, settlements bring change. Because when you hit an institution in the pocketbook, all of a sudden, sometimes people actually start looking at things and creating better policies or enforcing their own policies. Not always, but there is good that comes from settlements as well. You don't have to go to trial, but sometimes when we do go to trial, then yeah, that's splashy. But Mandi, I am so excited about this book. I can't wait to see it. I think it's going to be an eye-opener for a lot of people.